Can I apply for a green card after entering the US on a visitor visa? Yes and no. It can either be yes or no. Surely it can be both. Well, it can. And here's how. Hi, I'm Shariq and I'm the South Asian attorney. So some of you have likely heard about the 90-day rule. Under this rule, the government presumes that a non-immigrant or a temporary visa holder, like a B1, B2 tourist visa, committed misrepresentation if they applied for a green card within 90 days of entering the US. Misrepresentation leads to inadmissibility. Yeah, it means that you can get a green card. Well, you just came to the US on a valid tourist visa and now you want to apply for a green card. That's not really lying. How's that lying? To answer that question, we must determine if you had a non-immigrant intent when entering the US. A US immigration officer presumes that everyone traveling to the US intends to stay in the US permanently. Therefore, to get a tourist visa or any other immigrant visa, you must prove to the immigration officer conducting your interview that you intend to return home after your visit ends. This intent to return home is called non-immigrant intent. I'll come back to that concept in just a few minutes. Most non-immigrant visas are single intent visas, which means that at the time of entering the US, you should only have one intent, the non-immigrant intent. Some examples of single intent visas are tourist visas and student visas. The non-immigrant intent for a tourist visa requires you to possess proof of ties that will bind you to your country. These ties include evidence of ownership of property, long-term employment, and presence of close family members in your home country. However, in the case of a student visa, younger applicants applying for it will typically not have the same kind of ties I mentioned above. And that's because they're often single, unemployed, and without property. Additionally, most students will come to the US to complete a 4-year bachelor's degree or a 2 years master's degree, and thus are required to stay in the US longer than many other types of non-immigrant visa holders. Therefore, the consular officers issuing their visas will consider the immigrant intent in a broader light. They'll issue the visa if they find that the student applying for the visa has a present intent to depart the US after their studies. However, in the future, changing your intent to depart the US and applying for a green card does not really give USCIS sufficient reason to deny your application. If you're finding this video helpful, please like and subscribe. It really helps my practice grow. A dual intent visa allows you to enter the US as a non-immigrant, but it enables you to apply for a green card in the future. So a dual intent visa means that you have both an immigrant intent and a non-immigrant intent at the same time. In other words, you're really telling the government, hey, I'll leave the country when it's time, but while I'm here, I'm going to apply for a green card. Under the dual intent doctrine, even if you have a non-immigrant intent, you should not be disqualified from getting a green card. However, you should still intend to leave the US before your stay expires. So some examples of dual intent visas are H-1B and L-1. So we've been talking about the intention to get a green card. How do you really apply for a green card? There are 2 ways to apply for a green card, and they are adjustment of status or consular processing. To adjust your status or apply for consular processing, first a family member or an employer will file a petition on your behalf. This is just to prove that they have a family or an employer-employee relationship with you. So after your petition is approved, you have to wait for your turn to apply for a green card, in most cases. When it's time, you're going to apply for adjustment of status if you're within the US, or consular processing if you're abroad. You can also apply for consular processing from within the US if you want to. Consular processing means that you apply for your green card through your local consulates, or it could be embassies. However, if you apply for the AOS, you'll apply with the USCIS. Okay, so what constitutes misrepresentation? Misrepresentation is a false or misleading statement intending to deceive. It can also be an omission or an absence of a statement when you're required to make it. Some people assume that they can enter the US on a tourist visa, but then apply for a green card once they're here. But if you're entering the US intending to get a green card on a single intent visa, you don't really have the intention to depart. And when you lack this intention, you lack the non-immigrant intent. Because you lack the non-immigrant intent, You actually have the intention to deceive the US official. Additionally, when you don't tell the US officials about your intention, when you're really required to tell them, you're making a false statement. And because you're making a false statement with the intention of deceiving the US officials, you're committing misrepresentation. Many people commit this act and even get away with it, but that doesn't change the fact that it is misrepresentation. Okay, now that we've established the act of misrepresentation, let's talk about the 90-day rule. The 90-day rule is a presumption that non-immigrant visa holders who apply for a green card within 90 days of arriving in the US have misrepresented their intention to depart the US. Because the 90-day rule is a presumption, the burden is on the person applying for the green card to prove that they did not actually commit the misrepresentation. Therefore, if you can prove a lack of misrepresentation, you will become ineligible to get a green card. This 90-day rule applies to all officers in consulates and embassies. No, USCIS officers do not use a 90-day rule. In other words, if you're applying for an adjustment of status from within the US, the 90-day rule will not apply to you. USCIS stopped using this rule in July 2021. However, they do have their own guidelines to evaluate misrepresentation. If the USCIS officers have evidence that you committed misrepresentation, they will find you inadmissible and deny your green card. And this is regardless of applying for a green card from within 90 days or beyond the 90 days. Notably, the officers have a broad latitude in determining if an applicant committed misrepresentation. Therefore, tourist visa holders should avoid certain acts before coming to the US. These acts include selling your house in your home country, quitting your job, selling your business, marriage to a US citizen within the first few days of entry, filing for AOS shortly after arriving in the US, etc. However, the 90-day period may still be a good guideline. Because the USCIS officers have broad discretion, they can still find your actions to be misrepresentation. So, does the 90-day count start after you get your visa? Or does it start when you enter the US? It actually starts on the day that you enter the US. If you have more than one entry to the US, you'll start counting the 90 days from your most recent entry. You can determine the entry date by checking out the date on Form I-94. The 90-day rule applies to your most recent visa. For example, suppose you originally entered the US on a dual entry visa, like the H-1B, but later left and returned on a B-2 visa. In this case, your most recent visa, which is the B-2, will be considered for applying the 90-day rule. If you have questions or want us to proceed with your application, please schedule a consultation. Again, if you found this video helpful, please like and subscribe.